Welcome to this block of instruction, Understanding the First Amendment and the Key Principles for Law Enforcement. This is a high-level brief overview of the First Amendment of the United States Constitution. We will cover key components including freedom of religion, freedom of speech, freedom of the press, freedom of assembly, and the right to petition. As I mentioned, this is a brief overview of the First Amendment. However, as law enforcement officers, understanding these rights is crucial for effectively engaging with the public. If you need more guidance on navigating the rights established under the First Amendment as they pertain to your duties as a law enforcement officer, please seek out your agency's training officer, legal staff, or local prosecutor's office. Should you go on to attend the Law Enforcement Academy, you will receive more in-depth training on constitutional law. If you have not already been sworn in, you will be upon completing your training requirements. When being sworn in, you will swear to uphold and defend the Constitution of the United States and the state of Indiana. Please do yourself a favor, read and study these constitutions so that you know what you are swearing to uphold and defend. The First Amendment was written by James Madison, who was a leading advocate for freedom of speech, freedom of the press, and religious liberty during the founding era. The First Amendment guarantees a range of individual rights that are fundamental to American democracy. As you can read on the slide, the First Amendment states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble, and to petition the government for redress of grievances. It is essential to recognize how these rights operate and their significance in law enforcement. The freedom of religion includes two main clauses. The Establishment Clause, which prohibits the government from establishing an official religion, and Free Exercise Clause, which protects individuals' rights to practice their religion freely. Officers must respect diverse religious practices and understand these rights when in the performance of their duties. Freedom of speech is vital for a democratic society, enabling individuals to express thoughts without fear of government retribution. However, there are exceptions, and while there are exceptions, it is important to understand the context to which the speech is being used to know whether it is protected or not. Let's take a look at those exceptions. Though broad, freedom of speech has limitations. Fighting words, true threats, and obscenities are not protected under the First Amendment. Fighting words are defined as speech that incites immediate violence. Chaplinsky versus New Hampshire, decided in 1942, is a key Supreme Court case that involved a man named Walter Chaplinsky who was arrested for offensive and provocative language in a public space, specifically calling a city marshal a damned fascist. The Supreme Court ruled that certain categories of speech, such as fighting words that provoke immediate violence or disorder, are not protected by the First Amendment. This decision established that while free speech is a fundamental right, it does not protect expressions that incite violence or disturb the peace. As new police officers, it is important to understand that while individuals have the right to express their opinions, there are limitations when such expressions may lead to public disorder or harm. True threats. True threats involve statements that would cause fear of harm or defamation of one's character. Virginia v. Black in 2003 is a significant Supreme Court case that addresses the balance between free speech and the regulation of hate speech, particularly pertaining to cross-burning. The court ruled that a Virginia law banning cross-burning with the intent to intimidate was constitutional, as it aimed to prevent hate-based violence and intimidation. However, the court also emphasized that cross-burning, when not intended to intimidate, is protected symbolic speech under the First Amendment. This case underscores the importance of understanding context and intent when it comes to speech, as not all expressions are protected if they serve to threaten or intimidate individuals. As law enforcement officers, it is crucial to recognize the fine line between protecting free speech rights and upholding laws designed to maintain public safety and order. Obscenity is determined by the community standards and must meet the Miller test, which was established in Miller v. California, and is a landmark U.S. Supreme Court case that established a new standard for defining obscenity in relation to First Amendment's protections of free speech. The case arose when Marvin Miller, who was convicted for distributing unsolicited sexually explicit materials, challenged his conviction by arguing that it violated his free speech rights. The Supreme Court ruled that materials could be deemed obscene and thus not protected by the First Amendment if they met three criteria. They appealed to prurient interest, depicted sexual conduct in a patently offensive way, and lacked serious literary, artistic, political, or scientific value. But then in 2010, in United States versus Stevens, a Supreme Court case that involved a federal law that criminalized the commercial sale of depictions of animal cruelty, which was challenged by a man who created and sold videos showcasing such acts. The court ruled that the law was overly broad and unconstitutional because it targeted speech that did not meet the historical categories of unprotected speech, such as obscenity or incitement to violence. The decision emphasized that free speech protections extend even to distasteful or offensive expressions, as long as they did not cause direct harm. This case serves as an important reminder for law enforcement to consider First Amendment rights carefully when handling expressive conduct. As law enforcement officers, you have the right to free speech, but your statements can be scrutinized. Keep in mind court rulings such as Pickering versus the Board of Education, which happened in 1968. This case emphasizes that speech by public employees must balance concerns of the government's interest. In this case, a teacher was dismissed for writing a letter to a newspaper criticizing the school board's allocation of funds, which the court ultimately found to be protected speech under the First Amendment. The court ruled that public employees do not forfeit their right to free speech when they take on public employment, provided their speech addresses matters of public concern. However, the court also established that government employers can impose certain restrictions when their interest in maintaining an efficient workplace outweigh the employee's free speech of rights. For new police officers, this case underscores the importance of understanding your rights to express opinions on public matters while also recognizing the need to maintain professionalism and the effective functioning of your department. This includes social media and online activity. Do not, I'll repeat, do not get into arguments online. Exercise good judgment and remember that online communications are forever, meaning that once you hit that send or post button, what you have said is out there forever. Also remember that we spoke earlier about the importance of knowing the context of the speech. Online or electronic speech can easily be taken out of context, meaning that others will interpret your message in a million different ways. So again, be very cautious as to what you send or post, and check your department's policies and procedures to ensure you are operating within the scope of your agency. Freedom of the press empowers journalists to investigate and report on matters of public interest. As officers, when dealing with the media, it's important to maintain a balance of transparency with operational integrity and comply with public records requests and respect journalists' right to gather information. provided they are not interfering with law enforcement activities. Your job as a law enforcement officer at a scene is to ensure the safety of everyone and the evidence contained within the scene. There are times that either folks that identify as First Amendment auditors or legitimate media personnel in their efforts to document what is occurring enter an emergency incident area, which is defined under Indiana law as the area surrounding a structure, vehicle, property, or area that is defined by police or firefighters with flags, barricades, barrier tape, or other markers, or 25 feet in all directions from the perimeter of the emergency incident, whichever is greater, or a specific distance less than 25 feet in all directions from the perimeter of the emergency incident that is articulated by a law enforcement officer, i.e., you need to stand across the street. You need to go back into the house. Remember to remain calm and professional and ask them to leave the scene. Before you tell them to leave, you should have formulated a plan on what you are going to say and be able to explain to them why they need to leave, i.e., for safety concerns, evidence contamination, or that they are interfering with the investigation. Also, show them where a good place for them to be is. Ensure that the place you tell them to go is safe, but still gives them a vantage point to gather information and report the matter of public interest. In the event you have someone that refuses to leave, the state of Indiana has several laws that you could charge someone with. To enforce these laws, the person encroaching or refusing to leave must be in an emergency incident area, as discussed on the previous slide and as defined under Indiana Code 35-44.1-4-2. You must request that they leave before they may be arrested. This statute allows for a firefighter to tell someone to leave as well as an officer. Refusal to leave emergency incident area is defined as a person who is not a firefighter who knowingly or intentionally refuses to leave an emergency incident area immediately after being requested to do so by a firefighter or law enforcement officer. That person commits a Class A misdemeanor. Under Indiana law, interfering with public safety means to knowingly or intentionally enter an area marked off with barrier tape or physical barrier after being denied entry by firefighter, the emergency medical services provider, or a law enforcement officer. If a person does that, they commit a Class B misdemeanor. Encroachment on an investigation. When a person knowingly or unintentionally approaches within 25 feet of a law enforcement officer lawfully engaged in the execution of the law enforcement officer's duties after the law enforcement officer has ordered the person to stop, commits a Class C misdemeanor. There is a caveat to this law. There have been several civil lawsuits filed about this new statute, and as of October 1st, 2024, a preliminary injunction has been issued. Make sure you confer with your local prosecutor's office prior to making an arrest under this statute. Remember, the press have rights protected under the First Amendment of the United States Constitution and Article 1, Section 9 of the Indiana Constitution. As an officer, when dealing with the media, remember to remain calm and professional, as they are most likely always filming you, whether it be on camera or just audio. Either way, they have the right to do so, so don't get caught up in the fact that they are recording you. Also know that the establishment of a PIO, or a public information officer, at the scene who has been trained in dealing with the media will help mitigate many of the problems officers commonly face when dealing with the media. The freedom of assembly allows individuals to gather for protest or demonstrations and is protected under the Constitution as long as it is done peacefully and lawfully. It is crucial to differentiate between peaceful assemblies and unlawful gatherings. An example of a peaceful assembly is a group of people that are in a public place, not obstructing traffic to include vehicular or pedestrian traffic, and quietly walking around with signs and banners protesting a certain cause. Unlawful assembly or rioting, which is defined under Indiana law as an unlawful assembly that recklessly, knowingly, or intentionally engages in tumultuous conduct. What is tumultuous conduct? Tumultuous conduct is conduct that results in or is likely to result in serious bodily injury to a person or substantial damage to property. Unlawful assembly is defined as 5 or more people with a common objective to commit an unlawful act or unlawful act by unlawful means. The group can be formed prior to assembling or after they individually gather. Officers should approach situations calmly and avoid escalation. During protest, law enforcement should practice de-escalation techniques and avoid confrontations or escalating the situation. Best practices for dealing with protest include ensuring public safety, maintaining a calm presence, and facilitating dialogue with event organizers. Understanding local laws and ordinances regarding permits for assemblies can help ensure compliance from all parties involved. Officers responding to assemblies should identify the leader of the assembly and establish a good rapport with them. Good, transparent, and honest communication with the leader or leaders can help ensure a safe and lawful gathering. The right to petition allows individuals to appeal to the government for remedies. The right to petition, enshrined in the First Amendment of the U.S. Constitution, has its roots in colonial experience where American colonists faced oppressive governance and sought to voice their grievances against the British rule. This right reflects the fundamental principle of democracy, empowering citizens to advocate for change, seek redress, and hold their government accountable. Historically, petitions have been crucial in shaping policy and fostering social movements such as the abolishment of slavery and civil rights. The framers of the Constitution recognized that an engaged citizenry is vital for healthy democracy, and thus, right to petition serves as a safeguard against tyranny. This means that individuals have the right to make complaints or seek assistance from the government without fear of punishment or retaliation. The right to petition can take various forms, including filing lawsuits, lobbying for legislative changes, or simply voicing concerns to public officials. It is a crucial mechanism for holding the government accountable and ensuring that citizens' voices and needs are heard. As law enforcement officers, understanding and respecting this right is essential in upholding constitutional freedoms while ensuring public order in a democratic society. In summary, it's vital for police officers to respect and uphold the First Amendment rights while ensuring public safety. These rights protect individual freedoms while providing you with the tools to navigate complex situations involving the public. Understanding exceptions, effective engagement with the media, and proper handling of assemblies will enhance community relations. Now, discuss First Amendment with your agency representative. Make sure you know how your agency and local prosecutors expect you to handle First Amendment issues. Also discuss your agency's policy on your First Amendment rights, like social media use and your right to assembly. That concludes this presentation. Stay safe and good luck.